Très bien, merci beaucoup, Maître Taylor. La Chambre est prête à entendre votre collègue.
Merci, Monsieur le Président, Madame les Juges. As it is the first time I'm addressing the Chamber during this session, I would like to greet the Chamber and everyone here and our guests in the gallery as well. As Ms. Taylor outlined, I will make submissions addressing the prosecution's failure to prove chapeau requirements regarding situations of armed conflict and crimes against humanity, as well as discussing the fatally flawed evidentiary foundations in this case. I would like to begin with our submissions regarding the existence of and nexus to an armed conflict. We submit to you that accepting the prosecution's arguments here would not only contravene the evidence before the court and the previous case law of this court, but it would seriously weaken the ability to identify and litigate armed conflicts around the world according to the prevailing legal standards. Yesterday, the prosecution told a story that some may find compelling on the surface, but which contained no reference to the law and precious little reference to facts in support of the law. The reason is because neither facts nor law support the prosecution of this man, these crimes, in this court. As my colleague Ms. Taylor did, I'd like to start with the law and the legal standards and then focus on the facts and evidence before this chamber. The prosecution failed to prove beyond a reasonable doubt the threshold legal standard for jurisdiction, whether an armed conflict existed at all. There's a long-standing distinction in international humanitarian law between an armed conflict and less serious forms of internal violence that may be harmful but cannot rise to the level of armed conflict in order to prove the existence of an armed conflict. As the Chamber is aware, the prosecution must prove sufficient organization of the groups and intensity of violence. I'd like to start with the prosecution's attempt to show organization of the groups. At paragraph 704 of the Taganda trial judgment, the Chamber provides a non-exhaustive list of roughly 18 factors and indicators to be analyzed in order to find sufficient organization of an armed group. These include details related to command structure, unified military strategy, implementation of Common Article 3, the ability to speak with one voice. Under Taganda and its predecessors, the prosecution had the burden to prove, beyond a reasonable doubt, that some combination of these factors existed with respect to the groups in Mali. But what the prosecution asks this chamber to find for the first time in an international court or tribunal is that a single factor can be individually determinative. In the prosecution's words, the ability to conduct complex military operations, including to take and hold territory. Nowhere in the prosecution's arguments, either oral or written, is reference to the rest of the factors with respect of any of the individual groups in Mali whose acts the prosecution later seeks to aggregate, and I'll speak about that in a moment. In Taganda, the trial chamber went through each of these categories methodically and in turn over 6 paragraphs, paragraphs 704 to 709. In the present case, we submit that this chamber would be unable to provide the same analysis in a trial judgment that the Taganda chamber provided, not only because of a lack of argument by the prosecution, but because of the lack of evidence on the necessary criteria. The prosecution yesterday, and in their response to the defense final brief, specifically refer, in passing, to Al-Qaeda and Ansar Deen as possessing sufficient organization for an armed conflict. And so with respect to those two groups, we submit the following. With regards to AQIM, from January 2012 to January 2013, according to P99, AQIM was composed of disparate brigades without unified leadership, with many of those individual parts remaining uninvolved in the conflict. According to P4, AQIM had no unified strategy, nor was there any clear command structure. These were prosecution witnesses. Critically, the evidence has shown that Timbuktu was administered by AQIM not after complex military operations, but rather after abandonment by the Fama. And prior to their entry into Timbuktu, there is no probative evidence that AQIM exercised territorial control over any specific areas in northern Mali. So the single organizational factor set forth by the prosecution to establish an armed conflict did not exist prior to April 2012. The prosecution here attempts to use the holding of territory as a single factor in isolation to retrospectively claim an armed conflict for the purpose of jurisdiction here. With regards to Ansar Deen, there's likewise no evidence that shows that Ansar Deen promulgated military regulations during this period or had any system to discipline its members. According to one prosecution witness, Ansar Deen lacked sufficient strength to face a conventional army, which the trial chamber in Boskoski found significant to its lengthy analysis of whether, I apologize, Your Honors, should I pause? Okay. Which I alluded to the fact that the...
Non, non, maître, poursuivez s'il vous plaît. Non, non.
Thank you, Your Honors. I alluded to the fact that the trial chamber in Boskoski found a group's strength to face a conventional army significant to its analysis of whether the Albanian National Liberation Army possessed the requisite organization in that case. The prosecution has the burden of proof on this point, and even in their response, they fail to carry it. Moving to intensity, the second factor. The prosecution tried to show the intensity of a purported armed conflict by adding together everything that all the groups present in Mali were allegedly responsible for to try and reach that threshold. Now, groups can, of course, act in concert, but there is a legal standard for when you can combine the acts of different groups, which the prosecution has entirely disregarded, because it means not only that they have to prove the organization of each individual group, but that they have to prove intra-group organization of some sort. The ICRC states that proving or coordination and cooperation among groups in a non-international armed conflict requires the showing of a number of factors, including, for example, establishment of a joint centralized command, allocation of areas of responsibilities, sharing of operational tasks, the existence of common standard operating procedures or rules of engagement, and the existence of an umbrella platform dealing with political issues and communication in the names of the members of the coalition. The evidence in this case shows that to attempt an argument that these groups were acting in concert would contravene the facts that we have about the distinct methodologies and philosophies of the groups. prosecution witnesses testified regarding, for example, the opposition of AQIM and Ansar Dine to the rapes and pillaging conducted by the MNLA. My learned colleague yesterday highlighted that Ansar Dine and Al-Qaeda, quote, chased out the MNLA, end quote, from Timbuktu. How would they have done so if the groups were working in concert? The evidence overwhelmingly illustrates how fractured and even at odds the various groups were. And their acts cannot possibly be grouped together to qualify them as a combatant side fulfilling the intensity standard of an armed conflict. The prosecution cannot show an armed conflict, and they certainly cannot show that any purported armed conflict continued after the Fama left Timbuktu. You heard the prosecution refer yesterday to the internal military coup d'etat in Bamako and tried to tie that coup to the proposition that Ansar Dine and AQIM took Timbuktu. The reality is quite different. As mentioned, the Fama collapsed due to defections following the coup, as detailed by the international community, including, for example, the International Crisis Group, and confirmed by prosecution witnesses, including P-1086. Now, if, Your Honors, despite evidence to the contrary, this chamber finds that an armed conflict may have existed among scattered groups and over sporadic periods of time, there is simply no nexus shown between the armed conflict itself, as purported, and the acts with which Mr. Al-Hassan is charged, which are based on the application of civilian regulations. The prosecution has stated in its response to the defense final brief that, quote, the ICRC has long argued that situations where a non-state armed group establishes control over territory and then seeks to impose its own rules upon the civilian population are precisely those in which international humanitarian law should apply, end quote. In reality, the ICRC has long argued no such thing. In fact, the single article by a legal scholar that the prosecution provides for this statement at footnote 78 of their response. In that article, several authorities are cited for the opposite proposition, that in fact, with regard to everyday life, including interactions among civilians, human rights law is the more appropriate and protective legal framework that should apply. The author himself, Dr. Rodenhauser, notes that, quote, the interpretation of the nexus requirement as presented in this article, his own article, has been criticized as a one-sided approach to civil war that does not sit well with the fundamental principles of IHL, by which all parties to a conflict are regarded as equal. That principle of equality is, in fact, one that has not only been long argued by the ICRC, but long resolved, and applies to the civilian administration of Timbuktu during the charged period. In armed conflict, the law enforcement paradigm exclusively governs the exercise of administrative, disciplinary, and judicial authority over occupied territory, and the civilian population and persons deprived of their liberty. In Timbuktu, after April 2012, the evidence shows that there was a complete vacuum of governance. When Fama left, the civilians were left without police or judges or infrastructure to regulate anything. And the population was left vulnerable. This was the point at which AQIM and Ansar Dine stepped in to form an administration, not by their own rules, but in fact implementing widely accepted elements of the Maliki school of Islamic law, which is prevalent in North and West Africa, and countries including Kuwait, Bahrain, Qatar, Dubai, and northeastern parts of Saudi Arabia. As my colleagues, Mr. Youssef and Dr. Gary, will also discuss, the Maliki approach was established as policy prior to Mr. Al-Hassan joining the Islamic police, and as evident from its prevalence, is consistent with international law and cannot be read to be inherently inconsistent with international law. The neutral status of police and law enforcement, unconnected to any existing armed conflict, was given special consideration during the drafting of the Geneva Conventions. Regardless of varied opinions of the establishment of Sharia and the administration of Timbuktu by AQIM, it seems that those facts alone underpin the prosecution's insistence that an armed conflict existed from April to December 2012 for the purpose of prosecuting Mr. Al-Hassan in this court. Even more troubling, while policing civilian activity, again, is generally unrelated to armed conflict, it seems that the mere addition of the word Islamic to the title of the police makes Mr. Al-Hassan some sort of combatant, even though the Islamic police, as you've heard from my colleague Ms. Taylor, played the same role within Timbuktu as virtually any other police force in the world. If individual excesses occurred within the governments of Timbuktu, they occurred in the same way that incidences of murder, rape, and assault are found to be committed by members of, for example, the New York City Police Department, and handled under regular criminal law, even though the United States has been in a purported armed conflict since 2001. And of course, the preponderance of the crimes in Timbuktu outlined by the prosecution yesterday were not even committed by the Islamic police, but by other governing agencies. Distortions of humanitarian law, like those proposed by the prosecution, simply cannot be the basis for war crimes charges in an international court, and could have serious consequences for the universality of international humanitarian law. We submit that a proper application of the law in existence at the time of the charged acts results in a conclusion that no nexus existed between the police functions in Timbuktu and any purported armed conflict. I'd like to move to a discussion of the chapeau requirements of crimes against humanity. A fact-based inquiry shows just how difficult and complex the situation was on the ground in 2012. We do not envy our learned colleagues in this respect, but they have the burden to prove under Article 7 of the Rome Statute that AQIM or Ansar Dine actively promoted or encouraged an attack against the civilian population as an organizational policy. As you've heard, Islamic tribunal judgments were instigated through complaints submitted by civilians and concerned a range of issues, much of it essentially magistrate work. Such civilian-triggered functions cannot logically constitute an attack or a crime against a civilian population at large. According to witnesses D605 and P654, the judgments themselves were issued by tribunal members who were not all affiliated with either AQIM or Ansar Dine, and who made independent judgments that sometimes conflicted with Ansar Dine or AQIM policies. Prosecution witnesses P152 and P150 described how Ansar Dine and AQIM leaders, such as Drukdel, actually disapproved of severe punishments during the charged period, and that compensation was paid to individuals. Now, does this mean that no crimes took place during this period? Certainly not. And we have heard from the victims of some of those crimes committed by individuals who were not Mr. al-Hassan. And while terrible in many respects, they do not fall within what this court categorizes as atrocity crimes. Regarding those individual crimes, I heard reference by the prosecution yesterday to Mahmoud Musa. But what was left out was that we know that Mahmoud Musa was a member of the MNLA for the first part of 2012, when, according to prosecution witnesses and the United Nations, the MNLA was involved in mass rape and pillaging. Mahmoud Musa later led the Hezbollah, after which he was individually responsible for crimes against women and other civilians, and encouraged others to commit such crimes. But we also know from witnesses, including D605, that the organization opposed Mahmoud Musa's illegal acts, and that the situation improved once he was replaced, as Ms. Taylor just discussed. We also know from D202 and D605 that Ansar Dine investigated rape complaints and punished perpetrators. And throughout, the 40 men of the Islamic police were distinct from the Hezbollah. And it is that critical distinction that the prosecution is trying to obfuscate again and again in characterizing Mr. al-Hassan and his role here. We submit that nothing in the evidence before this chamber about the punishments suggests that they were widespread or systematic as required by Article 7.1. As tragic as many of us find such uses of force, the single amputation and handful of punishments over 9 months cannot constitute an attack, much less a widespread or systematic one, against a civilian population in Timbuktu of 780,000 people. The prosecution yesterday tried to extrapolate from the crimes that actually took place to a generalized atmosphere of abuse in Timbuktu. To the contrary, Even the United Nations, in a report issued in November 2012, in the record at MLI OTP 0001 2113 at 2117, the United Nations there characterized the number of abuses in November 2012 as not high. The seriousness of the individual events is still not the same as the weight that must be given by this chamber to the legal standard in assessing a prosecutable crime against humanity. There are two clear conclusions here. The first is that Mr. Al-Hassan himself has tenuous, if any, connection to the crimes that took place in Timbuktu in 2012, and no oversight responsibility for them. He was one man of 40 in a subordinate agency. The second conclusion is that there was no policy to commit crimes constituting a widespread or systematic attack on civilians that was promoted by any particular organization, including Ansar Dine or AQIM. I'd like to turn now to the contamination of evidence in this case. It is our submission that there are 4 factors affecting the evidence here. The first is race and ethnicity. The second is pervasive public bias promulgated by media and NGOs. The third is the sheer passage of time. And the fourth is torture and cruel, inhuman, and degrading treatment affecting the probative value of evidence. I will address each of these in turn. First, we submit that race and ethnicity is a huge factor in this case. Mr. Al-Hassan is a Tuareg, a member of the minority in Mali, and P160, for example, admitted that Tuaregs were, quote, automatically associated, end quote, with Ansar Dine or the MNLA, which is problematic because, in fact, as I mentioned, the MNLA was the group largely responsible for rapes, not Ansar Dine. This morning, my learned colleague from the legal representation for victims said that victims, quote, use words such as jihadist or Tuareg, and he called such words, quote, keywords, seemingly interchangeably. I cannot think of a better illustration of this pervasive bias. Arabs, collectively, were sometimes basically associated with Mujal or AQIM. P160 also conceded that individuals in Timbuktu found it difficult to distinguish between responsibility of individuals, they blamed groups as a whole, and if they knew the identity of a perpetrator, they would blame the group associated with that ethnicity. The second factor that I'd like to address is bias. And NGOs and the media, sadly, played a key role in shaping false narratives throughout 2012 and after, regardless of intention. We heard evidence concerning the way in which, for example, the Wildaf Project, one of several NGOs on the ground in Mali, how that project unfolded with highly questionable documentation processes. Another NGO that shaped the bias on the ground was the FIDH. P642, for example, testified that the FIDH led witnesses to believe that they would receive aid as a result of their claims. And the evidence shows that several prosecutions and that's at transcript 152, page 80. We heard this morning an extraordinary statement, again, from my colleague in the legal representation of victims, who stated, the locals, the identity of their occupiers was at one point unclear. They mixed ideas on it. Now, those things are totally clear to them at the end of this trial. That's at page 18 of the transcript from this morning. This statement actually forms a bridge between the factor of public bias and the third factor, passage of time. Witnesses were testifying 9 years after the events, which already affects memory to a certain extent. We know that prosecutors told P522 and P524 in 2016 that they did not want to take certain witness statements at that point, even though they would likely be more accurate closer in time to the events. And the reason the prosecution gave for not taking statements at that point was simply to avoid triggering disclosure obligations. And that record is MLI OTP 0037 1249 R1. Now, it does not take a memory expert to find clear tension between the prosecution's priority and the quality of the evidence. In the same document, there's an uncomfortable section describing how the prosecution team, quote, is reviewing the victim's procès-verbaux and finding ways to improve the quality of these procès-verbaux in terms of getting the type of information required to prove these specific crimes, end quote. So in 2016, 3 years after the events charged in this case, and 1 year before Mr. Al-Hassan was captured and interrogated, the prosecution just didn't have sufficient evidence to elucidate crimes committed that are prosecutable by this court. And now, in 2023, we submit that the process as now completed by the prosecution has been so flawed through witness influencing and the factors that I just mentioned that the probative value of the evidence has been stripped. Turning finally to the last factor, contaminating evidence in this case, the torture and coercion affecting the probative value of the evidence under Article 69(4). In the words of one prosecution investigator, Mr. Al-Hassan's conditions of confinement during ICC interviews were, quote, the same as Guantanamo Bay, end quote. That is a phrase that causes recoil, because everyone knows what Guantanamo Bay represents: torture and arbitrary detention, as found over and over again by the United Nations. That statement, caught on recording from the prosecution, was an admission. It was an admission that first, Mr. Al-Hassan was a victim of horrific abuse and torture. And second, that the ICC prosecution team was very aware of it. They did not torture Mr. Al-Hassan personally, but they still seek to benefit from the fruits of his torture in a court created in part to prosecute the crime of torture. And this is disallowed under Article 69(4). The court heard evidence confirmed by prosecution and defense witnesses that upon arrest, Mr. Al-Hassan was kept in a 1 meter by ½ meter room. He was waterboarded, he was threatened with electrocution and mock executions, interrogated while hooded, and subjected to additional techniques in combination. When transferred from French to DGSA custody, he was beaten until he lost consciousness, threatened with death and death to his family if he didn't answer questions to his torturer's satisfaction. He was subjected to falaka, beatings on the soles of his feet, stress positions, including being suspended from a metal rod for hours, and forced to relieve himself in his own clothes. For 9 months, as the prosecution interviewed Mr. Al-Hassan in the horrific conditions described by Ms. Taylor, he was being held arbitrarily, abused regularly, and other than the prosecution interviews, was incommunicado from anyone, including his family and from any regular judicial process. The chamber heard expert testimony, which confirmed that Mr. Al-Hassan's torture and coercion affected the the probative value of his statements when he was interviewed by ICC prosecutors to obtain evidence they have relied upon during this trial. The chamber heard from Doctors Catherine Porterfield and Juliet Cohen, who are world-renowned in recognition of the sequelae of torture, and from Dr. Charles Morgan, who's an expert on memory and the creation of false memories. Now, a quick note regarding these three experts. The prosecution has, in their briefs several times, complained baselessly about what they call flawed methodologies and a lack of neutrality regarding the defense experts. Now, in fact, the prosecution had the opportunity to cross-examine each of these experts on their methodologies and objectivity, and the expert opinions all held firm through such scrutiny. Each expert testified that they had all the information necessary to arrive at their conclusions based on their considerable professional experience. They explained how and why they disregarded certain evidence as unscientific. And, as specifically discussed by these experts, particularly by Dr. Porterfield, who conducted extensive in-person evaluations of Mr. Al-Hassan, Mr. Al-Hassan was specifically tested for malingering, exaggeration, or fabrication, with negative results. The testimony and reports of Doctors Porterfield, Cohen, and Morgan should be afforded the weight and credibility of experts with extensive experience in highly technical fields. And the conclusions that they reached all cast serious doubt on the probative value of Mr. Al-Hassan's evidence, as well as the prejudice that his evidence may cause to a fair trial. Dr. Porterfield testified that even in her evaluation years after the abuse, Mr. Al-Hassan showed signs of cognitive impairment that would have affected his interviews in 2012 and 2013. In response to the prosecution's argument that they informed Mr. Al-Hassan of his rights, including the right to remain silent, during those interviews before obtaining his statements, Dr. Porterfield testified the affirmation of detainee rights by the prosecution was, quote, overpowered, end quote, by the reality of the abusive and torturous conditions of confinement at the DGSE. These conditions created the environment by which Mr. Al-Hassan's evidence was impermissibly compromised. Dr. Morgan, independently upon review of Mr. Al-Hassan's interview transcripts, walked the chamber through a step-by-step analysis of false memories created by the prosecution's interview methodology. Now, false memories are not rare. They are well-documented phenomena in psychology wherein over 85% of people subjected to uncontrollable stress, as all the experts agreed Mr. Al-Hassan was, agree to narratives that are untrue. One of the incidences that the prosecution leans on in this trial is Mr. Al-Hassan's so-called admission to prosecutors that he personally participated in one particular man's flogging. In painstaking detail, following review of Mr. Al-Hassan's interview transcripts, Dr. Morgan described how that specific memory came to be created. He said, quote, I note this section of Mr. Al-Hassan's interviews because the process of OTP's questioning, quote, is like a recipe of what we would do in research to create a false memory, end quote. The detailed analysis is laid out in paragraphs 297 to 303 of the defense final brief. But in Dr. Morgan's words, quote, I highlight it because as you follow the course of the interview regarding this particular flogging, the progression is from Mr. Al-Hassan saying, "I don't remember," getting him to generally recognize and acknowledge that he recognizes a place, he perhaps recognizes an individual, and then showing him photos. And we find that photos or videos are very effective ways of influencing someone's memory. And adding in the narrative of how many people were being whipped and flogged, and including the phrase, "you were there." This is a direct example of how we believe we get false confessions from people in an interview process, whether or not it was intended on the part of the questioners. And that's T179, pages 47 to 51. Dr. Morgan found overall that the conditions of the prosecution interviews with both Mr. Al-Hassan and P626 were so pernicious that, quote, "it is within a reasonable degree of medical and scientific certainty that the information each of these witnesses provided during their sessions with the ICC investigation team is subject to substantial error." We submit that at an absolute minimum, there is reasonable doubt as to the probative value of Mr. Al-Hassan's answers to the prosecution's questions during this period of his abuse. His answers cannot be relied upon by this chamber under Article 69(4). The witness testimony heard by this chamber may change the course of a man's life. And so we submit that the veracity of it, regardless of intention, is what this chamber must examine. And upon examination of these four factors, it is clear that the prosecution's witnesses again and again conveyed inconsistencies and sometimes false and verifiably incorrect information that eviscerates the prosecution's case against Mr. Al-Hassan. Now, the prosecution makes an interesting statement in their response to the defense final brief, and this is at paragraph 124 of their response. They state, quote, "corroboration does not mean that two pieces of evidence must be identical in every particular, but it rather implies a fact-sensitive comparison of salient points based on the compatibility of two pieces of evidence with regard to the same or linked facts." Now, the long-established exception to that statement is that the testimonies to be compared must be prima facie credible. That's why the ICTR, in the Gatete appeals judgment, which is cited by the prosecution in support for that particular statement, made the distinction at paragraph 125 of that judgment that two testimonies corroborate each other when, quote, "one prima facie credible testimony is compatible with another prima facie credible testimony regarding the same fact or series of linked facts." We submit that unreliable memories created in witnesses shown to have experienced uncontrollable stress, as Dr. Morgan highlighted, in circumstances presenting a real risk that torture occurred, which is the legal standard, are not prima facie credible and therefore cannot corroborate each other. It is our submissions, as you've heard, Your Honors, that the evidence is clear that there was no armed conflict under IHL at the time of the charged offense. And in the alternative, any conflict had ended and had no nexus to the charged offense. The chapeau requirements of crimes against humanity instituted by this court were not met by the prosecution. And the prosecution yesterday placed emphasis on courts needing to have the safeguards generally recognized as being indispensable for a fair trial. I am sorry to say, those safeguards have not all been present in this prosecution. Among the safeguards that my learned colleague mentioned as indispensable were the following. First, people having access to court or judge to contest pretrial detention. Mr. Al-Hassan had no access to court or judge to contest his detention at the time that the OTP interviewed him. Second, respect of the right not to incriminate oneself. In pursuing interviews that under conditions that they themselves acknowledged to be coercive, the OTP violated this right of Mr. Al-Hassan when he stated repeatedly that he was not able to remember facts or was unwell and suffering from his treatment. They continued to violate that right. And third, among the safeguards, is prohibition of the use of torture, which includes the prohibition on torture-derived evidence that cannot be reliable or probative. The prosecution knew of Mr. Al-Hassan's torture and conditions of confinement at the DGSC. They never once ordered an investigation. They simply pressed on with their questioning. Mr. Al-Hassan's right against the use and exploitation of his torture may yet be safeguarded by this chamber through recognition that the taint that has attached to the evidence in this case is too heavy to be considered justifiable in any case, and it strips the evidence of its probative value. The International Criminal Court cannot ignore or benefit from injustice in the course of pursuing justice. Neither the intention nor control of the prosecution regarding any of the factors I've just outlined can excuse the procedural and substantive shortcomings in this case in a court of this consequence. And at this time, I'd like to hand the podium to my colleague, Maître Melissa Beaulieu-Lucier. I note that I lost time.
Oui, Maître Pradam, je ne pense pas que vous pouvez donner la parole à votre collègue parce qu'il est temps, enfin, presque temps. Il nous reste 2 minutes. Alors, avec les 2 minutes, ce n'est pas la peine. Maître Pradam, je voudrais vous remercier très sincèrement pour votre brillante présentation. Et je renouvelle évidemment mes remerciements à Maître Taylor également pour sa brillante présentation. Nous sommes arrivés à la fin de notre journée aujourd'hui.